Hello, my name is CJ410A, and today I'm going to take you through a walkthrough of a criminal circuit court in the state of Oregon. In this walkthrough, we're going to talk about the judges, the attorneys, to include the prosecution and defense, the court clerk, the bailiff. We will also discuss court structure and administration, courtroom decorum and legitimacy, and a contemporary court challenge. Now let's talk about different positions in the court. First, we'll discuss the judge. The judge is responsible for making sure all court rules are being followed that have been established by law. They also ensure the court is proceeding in an orderly fashion and hear and decide on objections made by the attorneys. In a bench trial, they are the ultimate judge in deciding whether the state has met the burden of proof, which is beyond a reasonable doubt. In a jury trial, they instruct the jury on what to expect and how to interpret the information presented. Lastly, whether in a bench or jury trial, they decide the sentence for the case that's been heard before them. Next, we move on to the attorneys. They're broken into two different sides. Here on side A is the prosecution, sometimes referred to as the state, because they are representing the local government in the case. Their job is to argue the case before the judge and jury, and with the use of witnesses and defendants, develop an oral argument using both physical and digital evidence along with witnesses that proves the defendant had committed the crime beyond a reasonable doubt. Depending on the case, one or more prosecutorial attorneys may be involved, but only one typically presents an oral argument. They usually spend months preparing for a case by reviewing all applicable evidence and speaking with the defense attorney about plea deals. They also attend status hearings for the case where they explain to the judge if they are ready for trial or not. Then on side B is the defense. The defense attorney represents the defendant in the case, the person who is being accused. If people cannot afford an attorney, they have a constitutional right to representation. In many states, there is a public defender's office that takes on these cases. In Oregon, it operates on a contractor system, where different lawyers from different law offices decide whether or not to contract with local circuit courts to represent clients. Otherwise, if you are found to have the means, you have to pay for an attorney using your own money. Depending on the case, a defendant may be represented by more than one defense attorney, but also they usually speak only one at a time. In most cases, people only have one defense attorney to ensure that the client's rights were not violated during the investigation, arrest, or trial. They also determine if the defendant is innocent, that it's important that they do their job to prove that they are indeed innocent by presenting the evidence and witnesses to the judge or jury. Due to the adversarial nature of the court system, it is sometimes more about winning rather than ensuring justice is served. And this is for both the prosecution and the defense. Next, we'll move on to the county clerk, or the court clerk, And this photo is represented to the right of the judge. The court clerk is often seen sitting next to the judge during a trial. They handle a host of administrative duties that keep the court running. This may include swearing in witnesses and juries. They also coordinate with the jury on deliberations and on when and where to meet. They mark and keep track of evidence in court, often called exhibits. They maintain the docket by entering rulings, filings, and other entries. They keep track of the court schedule and everything you can think of that needs to be recorded. Without the court clerk, the proceedings in trial could be very disorganizing, confusing, and lack legitimacy. This is not to be confused with a law clerk who may work for a judge in more of a legal research position. Next, we'll move on to the bailiff, who's to the right of the clerk. The bailiff's primary responsibility is safety in the courtroom. This is primarily the safety of the judge, but also extends to all participants and visitors in the courtroom. They coordinate safety issues in the court before trial and may request additional security based on the type of trial or the polarization of a specific trial. An example of this is a murder trial where the victim's family will be attending and emotions are high. They usually instruct everyone to rise when the judge enters the courtroom and help facilitate the removal of people from the courtroom at the judge's orders. In some jurisdictions, the bailiff is a full-time position and is present at each court proceeding, while others are only present for criminal trials and may have responsibilities or other responsibilities when not acting as a bailiff for a trial. The best way to summarize a bailiff is that they are the enforcement arm of the court. Now it's time to look at where level of court is the circuit court in Oregon. The circuit court in the state of Oregon handles all crimes that occur within the jurisdiction of the county, which are not handled by the municipal court. It is a court of record in a lower tier criminal court. People can appeal decisions made at the municipal court level, which is not a court of record, to the local circuit court. And when it comes to appealing decisions made at the circuit court level, they may appeal to the Oregon Appellate Court, and above the Oregon Appellate Court is the Oregon Supreme Court. And decisions at the Oregon Supreme Court level can be appealed to the U.S. District Court, and from the U.S. District Court to the U.S. Supreme Court. Then it comes to the authority, administration, and accountability of courts. The court has many positions of authority, with the judge sitting at the top of that authoritative chain. They can make decisions on what is allowed and what is not in a court or jurisdiction and are held in high regard in the court system. They often are referred to as Your Honor during trial. Prosecutorial attorneys also have a great deal of power. They can decide to bring charges, upgrade charges, downgrade charges, or choose not to pursue a case altogether. They can also attempt to offer plea deals before a trial even occurs, and they hold significant power and authority over how the law is enforced in a particular jurisdiction. Likewise, entities such as the clerks and other administrative parties in the court system determine when and where court proceedings take place and are responsible for tracking many cases from start to finish. This is a daunting task as criminal courts are often backlogged with many cases, and some cases can spend years on the docket before they are fully closed. Everyone in the court system, outside of the judge, has to answer to others as a measure of accountability. The clerks and the lawyers have to answer to the judge. The clerks and the lawyers themselves also have managers within their own chain of command who they have to answer to. And even when it comes to answer to the judge, there are also expectations from the community and legislators that courts be ran a certain way. Judges ultimately have to answer to voters or legislators if their court appears to be in disarray and not operating as expected. All of these pressures can be said to demand accountability, which in turn demands consistency and efficiency. Next, we're going to talk about decorum and legitimacy. In criminal court trials, appearance is very important. Everything from how the defendant is dressed, the lawyers are dressed, and what is required of those present denotes it is a venue of importance and that it is serious. This is why lawyers wear suits, the defendant is usually in a suit, and hats are not allowed in the courtroom. The structure and placement of tables, witness stands, and the seating of the jury and judge all denote order. To include all judges wearing black robes to show no individuality amongst judges, but they are called to judge fairly and impartially. When it comes to behavior, there's an expectation in the court and from the public that things are done not only professionally, but with fairness. If there's a perception of laxity with the rules and unprofessionalism, it undermines the court's legitimacy and its ability to be seen as an institution worth keeping and believing in. The court maintaining legitimacy is at the core of American society, and it is being seen as free and fair. A lack of decorum can weaken a very important institution in American society that many look to as being key to the fabric of our nation and its core principles. Next, we're going to talk about a contemporary challenge, which is judicial behavior. When it comes to judicial behavior and ethics in the criminal court, it is of the utmost importance, as a person's freedom is at stake. And as mentioned before, the institution must be seen as legitimate, otherwise it can adversely affect the fabric of our society. If judges are found to conduct themselves unfairly or unprofessional in their private lives, it can affect how the court is perceived. Same with attorneys. Say, for instance, a prosecution attorney is found to have planted evidence or chose not to introduce exculpatory evidence in a trial. It not only calls into question the fairness of that trial, but also every trial that specific attorney has ever prosecuted. If the defense attorney chooses to introduce a witness that they know has no nexus to the case or will lie, it can be seen as a slight tactic and call into question their ethics. It is easy to find news stories of judges, attorneys, and others in the court system falling short of what the public expects of them. Although it can be quite a process, it is more on the easier side to strip away licenses and positions from those in the court system, like judges, attorneys, and clerks. What becomes difficult, especially for the administrator, is trying to ensure both to the public and lawmakers that what had occurred was an anomaly for that specific court. Administrator also must investigate and also possibly institute rules, regulation, or procedures to ensure that whatever behavior has caused a stand on the court, it is not able to be conducted again or in a way that it could affect the public's trust in the court system. For the lack of a better word, it can be an administrative and operational nightmare to navigate, but it becomes necessary to uphold the standards expected of the court. This is the end of the presentation. I hope you enjoyed it. Here's my references. Thank you.